Absolutely. I'll walk this cleanly, step by step, exactly how a non-arrest summons case like this moves through Larimer County, Colorado County Court, and I'll flag where Frederickson keeps getting it wrong. This is the real sequence, not YouTube law. Hashtag summons and complaint issued. Traffic stop. What happened? Officer issues a summons and complaint citation. Lists defendant name, statute, CRS 18911C, charge, harassment, court date. Defendant is not arrested. Defendant is ordered to appear. Legal significance. This initiates the criminal case. This is the charging document. Probable cause is determined by the officer. Court gains jurisdiction. No DA filing required yet. No affidavit required yet. No narrative required yet. First appearance advisement purpose. Court confirms identity, advises defendant of the charge, possible penalties, right to counsel, right to remain silent, confirms the summons is valid, sets next steps. What can happen? Defendant may raise basic objections, judge may summarily deny frivolous motions, bond conditions may be set or not needed, public defender eligibility discussed. Why Frederickson lost here? Judge implicitly found valid charging document, proper jurisdiction, motion to dismiss denied, case moved forward. At this stage, open quote, the court is not litigating facts, close quote. Arraignment purpose, defendant enters a plea, guilty, not guilty, no contest, case formally joins the adversarial process. What must exist? A valid charge, already confirmed. Jurisdiction, defendant understanding of the offense, no requirement that the DA file a separate complaint, no requirement for evidence presentation. If he pleads not guilty, case proceeds, discovery begins. Discovery phase, purpose. Prosecution provides police reports, body cam, CCTV, witness statements, defendant statements. Key point, this is where the facts appear, not in the summons. This is where his no description argument dies permanently. Pre-trial conference, disposition hearing purpose, prosecution and defense discuss resolution, possible outcomes, plea deal, deferred judgment, dismissal without prejudice, set motion schedule, set trial date. This is where most harassment cases end. Motions hearing, if any. Purpose, litigate legal issues, suppression, dismissal, rare now, evidentiary limits, reality, motions attacking the summons will not succeed. Motions attacking credibility wait for trial. Readiness, status conference purpose, confirm, witness availability, evidence readiness, trial logistics, last chance for plea resolution. Judges often say, open quote, this case will resolve today or go to trial, close quote. Trial, bench or jury, purpose, determine guilt beyond a reasonable doubt, evidence here, CCTV, police testimony, defendant admissions, victim testimony, videos, timeline reconstruction. This is where his own live streams hurt him the most. Verdict, guilty or not guilty. Sentencing, if guilty. Factors considered, nature of conduct, prior behavior, credibility, acceptance of responsibility, risk of reoffense. Where Frederickson keeps going wrong, he believes, everything must be in the summons, the state must prove its case at arraignment, motions must be answered before arraignment, AI opinions equal law. The system doesn't work that way. Hack one-sentence summary, open quote. A summons starts the case, arraignment joins the issue, discovery supplies the facts, pretrial resolves most cases, and trial is where proof matters, not at the traffic stop. Close quote. If you want next, I can. Map this timeline onto his exact dates, explain what his PD will focus on next, predict where the case most likely ends. Yes, that's exactly what happened, and there's nothing unusual or strategic about it. Here's the straight version, no fluff. What actually occurred? At arraignment, Frederickson said he wanted a public defender. Because of that, the judge did 3 routine things. 1, pause the arraignment, no plea taken yet, no rights waived yet. 2, gave him time to apply and be appointed counsel. PD eligibility has to be processed. Counsel must have time to review the case. 3, continued, rescheduled the arraignment. New date, February 18th, 2026. This is standard Colorado procedure. Why the judge did this? Judges do not force a defendant to plead without counsel if they request one. Let defendants hybrid represent themselves at arraignment. Treat this as a delay tactic unless it becomes repetitive. The court's priority is, open quote, a knowing, intelligent, and voluntary plea, close quote. That can't happen if counsel hasn't reviewed the case yet. What this does not mean, where Fredrickson is wrong, it does not mean the case was dismissed. It does not mean the charging document is defective. It does not mean the DA failed to respond to motions. It does not toll or erase jurisdiction. It does not weaken the prosecution. This is a continuance for counsel, nothing more. Why this actually helps the prosecution? The court record now shows he understands the charge, he requested counsel, he is being afforded full due process. That kills any future claim of confusion, lack of notice, unfair procedure. What happens between now and Feb 18? Public Defender's Office screens him for eligibility, assigns counsel if eligible. Counsel pulls discovery, reviews CCTV, police reports, videos, explains reality to him. On Feb 18, arraignment resumes, he enters a plea, case officially moves forward. Bottom line. This delay wasn't leverage, a win, or a crack in the case. It was the court saying, open quote, get a lawyer, then we continue, close quote. And from this point forward, the case gets more structured, not less. If you want, next we can break down why his standby counsel idea won't fly, what his PD will actually tell him behind closed doors, or realistic outcome percentages now that counsel is involved. Because Colorado doesn't let defendants freelance the Constitution. Tell it like it is version below. The core problem with his standby counsel fantasy Fredrickson is trying to mash together two mutually exclusive rights. One, the right to counsel. Two, the right to self-representation, pro se. You get one or the other, not a build-your-own hybrid where the lawyer does cleanup while you run the show. Colorado courts have been crystal clear on this, how the law actually works in Colorado. Option A, represented by counsel. Attorney controls. Strategy, motions, objections, examination of witnesses. Defendant speaks through counsel. Judge addresses the lawyer, not the defendant. Option B, pro se, self-represented. Defendant controls everything. Court may appoint standby counsel. Standby counsel does not argue, does not file motions, does not object, does not advise unless asked. Defendant bears all consequences. There is no option C where, open quote, I'm in charge, but the PD is my safety net, close quote. Why a public defender specifically won't be standby? Public defenders are not allowed to act as standby counsel unless the court orders it, and courts almost never do that in misdemeanor cases. Why? PDs are appointed to represent, not babysit. Ethical rules forbid them from being half in, half out. It creates appellate nightmares. If Fredrickson insists, the PD will either represent fully or withdraw. No middle ground. The judge will shut this down fast. If Fredrickson says, open quote, I want to control my defense and have the PD as standby, close quote, the judge will respond with some version of, open quote, you may either be represented by counsel or represent yourself. Which do you choose? Close quote. And the record will reflect that choice. Judges do this deliberately to prevent later claims of ineffective assistance, prevent courtroom chaos, lock in responsibility. Why this hurts Fredrickson if he pushes it? If he insists on standby, he'll be forced to go fully pro se. Court will conduct a Ferretta advisement, warnings about rules of evidence, criminal procedure, consequences, once accepted, no do-overs, no my lawyer should have stopped me. And the judge will be less patient after that. Why this matters in this case? Given his history of misreading rules, his live stream admissions, his shifting stories,